Are now live in Law Day 2012. Welcome to all of our sites. We have Lowry High School in Winnemucca. Wheelchair is appropriate.
Everyone say welcome to the city.
We have at Devontae Ranch, we have Justice James Hardesty, Judge Scott Foreman, and John Polson.
Let's hear it.
Welcome. Are you guys ready? Okay. And here in Canyon Springs, we have Justice of the Peace Conrad Hafen, Public Defender Jordan Savage, Dr. Lou Grillo, Christine Rush, Laura Willis, and Mike Haney. Let's hear it for Canyon Springs. And to be sure that Debbie Watts and Renee Hill get their live billing right up front, they are also with us at Lowry High School. I am Nevada Supreme Court Chief Justice Nancy Seda. Law Day is coming to you this year from the 3 Nevada high schools that we've just identified. And I will tell you that we are most excited about the fact that not only are we live in 3 locations, but we are live on Twitter and on Facebook. And you have an opportunity to join us by going to, on Twitter, it is #LawDayLive, and on Facebook, go to http://www.facebook.com/LawDayLive. And we're going to allow everyone to have some time to join us in this important conversation as soon as we get going. Today we're going to look at how the courts protect your individual rights. We want to make sure that when we protect your individual rights, we are also upholding the laws of our country. We are going to talk primarily about the judicial branch of government today. Although it is one of 3 branches, it is nonetheless an independent but co-equal branch of government. And our obligation truly is to provide justice for all. Fair and open justice and full representation of a person accused is the vital stepping stone to all of democracy. Of course, that doesn't mean that you will always win or that your view about how the law should read or be applied is correct. The law changes. Landmark cases affect the rule of law, and frankly, every day in our courtrooms across this state and across the country, the law will change because judges and jurors are making decisions. By the time those decisions are tested in a Supreme Court, the law can change yet again. But it's important to understand what your rights are, how they can be enforced, and why they are important to you. In reality, the law is very complicated. That's why we have courts and judges. Let me ask you a few questions. Do you think that a school official can take your cell phone and look through it? I'm here in Canyon Springs. How many of my Canyon Springs students believe that the school officials can take your cell phone and look through it? Look at your pictures, look at all of your texts, look at your phone list. How many of you think that can happen? A single hand goes up here in Canyon Springs. Can your locker be searched without your permission? Okay, resounding belief that your locker can be searched, but your cell phone can't. Judge Hafen, what do you think about that? On school district grounds, can they search the cell phone? Take your cell phone, look through it?
Well, depending on the facts, I think you can. I've been in several cases, I think, support that yellow case and case. There, the United States Supreme Court, anyway, has indicated a lesser standard when it comes to school searching. So, again, it's going to be a factual determination, and so I think, depending on the facts, you probably could search the cell phone.
Well, you know, Judge, when I was walking in this morning, I saw a young man who came out of a hallway, and his trousers were riding a little bit low. And apparently there's a rule here on campus that you have to have your trousers up around your waist. I see teachers nodding. Is that true? Okay, so let's assume that Dr. Grillo was walking past this young man this morning with his pants hanging below where they're supposed to be. and Dr. Grillo said, I want to come over here, buddy. I want to see your phone. I want to take a look at what you're doing because you're breaking a school rule. Can we do that, Mr. Savage?
Well, I think that Judge Hiibel is correct. There's far less protection in the school atmosphere. That doesn't mean there's no protection at all. Access for a legitimate connection between the reason hurts and the violation issue. I think most courts would probably uphold search based upon search without any pain.
So the answer to the question is whether or not they can take your cell phone and take a look at it on school grounds is pretty resoundingly that I think they can. What we've touched upon is a lesser standard. On school grounds, it's a little bit different than if you were out on the street. On the street, Judge Hiibel, same thing? Can somebody just walk up because you don't look right and take a look at your cell phone?
No, because it's a different standard. Again, when talking about the school situation, I think the courts have indicated that's a special needs type exception to the warrant clause. But when you're talking about out on the street, up to a person and say, give me your cell phone without probable cause to do so.
Mr. Savage, you in agreement with that?
Yes, well, certainly our rights are, we have more rights in our home and on the street. I have given. To allow school authorities.
So now we're going to go outside of the school environment, and I'm going to ask you this question. If a police officer demands to know your name, you're on the street, like my bank robbery the other day, just minding her own business, walking down the street. If a police officer stops you and demands your name, do you have to tell him? How about in Winnemucca? Police officer stops you and asks your name. Do they have to give it? You have to give up your name?
It's a pretty overwhelming yes here from the gymnasium at Lowry High School.
How about in DeMonte? Police officer stops you, asks you your name. Do you have to give it up?
Yes. Come on, somebody say no. You said you're not saying no? Okay, well,
We'll get to that.
Judge Freeman and I say no, maybe.
Typical judicial officers. Typical judicial officers. Well, you know, the last issue about the cell phone and strike that, about a police officer asking you your name and whether or not you have to give that up, of course, as you know, actually took place in a case in northern Nevada, in Winnemucca, and we're going to talk about that case. Actually, that simple question of whether or not a police officer is entitled to have you give him or her your name went all the way to the United States Supreme Court. And that's a pretty lofty path to have to follow. I think that what's even more exciting for us today, we're going to talk about the Hiibel case where this issue arose, but we have almost every one of the people who were involved in the Hiibel case here present in the three locations with us. We're going to get to talk to the man who prosecuted Mr. Hiibel, the judge who heard one part of the case, who's now a district attorney. We're going to hear another judge who actually is Judge Wagner, who's present with us in Winnemucca. And then we're going to have comment from Justice Hardesty and Judge Freeman about the interpretation of that case and how it might apply to some expanded circumstances. But we're also going to talk today about the reality of your court system, and that is that your courts are facing very hard economic times right now. And while we can talk about all the rights that you have and all the protections that our Constitution provides to you, if your courtrooms are not open, if your courtrooms are underfunded and therefore cannot be adequately staffed, we would suggest that your access to justice may be impacted by those fiscal realities. So we're going to move today into the real theme of Law Day, which is no courts, no justice, and no freedom. And we're going to talk a little bit about how the daily activities in your courtrooms actually affect certain rights under the Guaranteed that you have, guarantees that you have in your Fourth and Fifth Amendments. What exactly does a Fifth Amendment right mean to you? Volunteers, students, what's your Fourth Amendment right? Yes, ma'am. Fourth Amendment right means what?
Our Fourth Amendment right means that we are protected against unreasonable searches and seizures. And that is a very important right. That's the most important one in the Fourth Amendment. And I believe that it shouldn't be violated by police officers. But there are some exceptions, as we have seen in the Hiibel case, where they can ask for your name. And as we have seen, it's unconstitutional for the police officer to do so.
Thank you. Thank you. One technical correction. I identified one of the participants in the Hiibel case as a DA. I'm so wrong, and I so apologize. Judge Wombold is one of our JPs. So welcome from your prior incantation to being with us today as a judge. My apologies for the error. We know that most of the students are going to want to participate in these questions and answer the questions that we have before us. I want to remind you, on your screen you should be able to see that we have both a Twitter account and a Facebook account. Please join us with your comment. We have a whole team of technology to my right that will be feeding me the questions that come from our Twitter and our Facebook accounts so that we're going to engage everyone. And I want to make something clear before I toss this over to DeMonte. This Law Day is about each and every one of you students in every site. It is not about the judges and the attorneys who are here to answer your questions. We want to hear from you. We want to hear your thoughts about the Hiibel case. We want to hear your thoughts about access to justice. And so with that, Justice Hardesty, Judge Freeman, I'm going to toss it over to you at DeMonte.
All right. Good morning, Chief. Good morning, Judge Montero and the students in Lowry High School, and welcome to the students here at DeMonte Ranch. This is an awkward setting because our back is to the students, so I don't know how we can change our chairs, but we'll try to figure that out. I want to introduce Judge Scott Freeman. Judge Freeman, as some of you may know, was just recently sworn in as a district court judge, and for most of his legal career has been a criminal defense lawyer. So these issues are issues that he dealt with in representing clients throughout his legal career, and is a very well-respected attorney and now a new district court judge. We learn from a very early age that we have three branches of government, and it isn't necessary to repeat that for all of these students. They understand that. Today we focus on the role of the judicial branch of government, which, as a member of that branch, in my opinion, is the single difference that separates the United States of America and our form of democracy from most countries in the world. If you think about it for a moment, the judicial branch is the branch which stands between you and the power of your government to affect your rights, to alter or impact the rights that the student that Justice Seda just spoke to, describing what are the rights of the your rights under the Fourth Amendment. Critical to the analysis of Fourth Amendment and Fifth Amendment issues, though, is the question, or two critical questions. What is probable cause and what is reasonable suspicion? I assume you've studied those subjects, but I'd like you to hear from Judge Freeman from his perspective about what those phrases mean and how they might be applied in the context of what we're going to discuss. Judge Freeman?
Thank you very much. As Justice Harsey said, I'm 1 foot away from being a criminal defense lawyer, and the rest of my body is now a district court judge. So as a consequence, I deal with these issues, and I've had the privilege of dealing with some of the parties that we're going to be talking about in the Hiibel case as well. But where do these rights come from, and where do we develop these rights and laws? It comes from the day-to-day operations and the day-to-day experiences that police officers have, and their job in protecting our citizenry. So what do? They come on a scene, and they're not really sure. It looks suspicious. They don't know what's going on. And they have to develop something called a reasonable suspicion, a reasonable idea as to why they're going to investigate further. You know, your constitutional rights are not really implicated or come into effect at that early stage. But as they develop, they can develop into something called probable cause, which is now a real reason to detain someone, to ask some additional questions. And that's where the interesting analysis comes from. The difference between an investigation at its early stages, reasonable suspicion, which can now evolve into probable cause. And so we saw in the Hiibel case is a police officer that comes on the scene as a result of a call of a domestic case. And certain circumstances evolve as he does his investigation. And so he has the ability to use common sense, the ability to use what the law provides for him, but then judges and lawyers analyze his behavior after the fact. And so that's really the difference between reasonable suspicion, beginning an investigation, which ripens or develops into probable cause. And then we all get to analyze it later.
Thanks, Judge. Judge Montero, you have most of the actors in the Hiibel case present with you. Would you like to take it from here?
Yes, thank you, Justice Hardesty, Justice Seda, and all of the students at both Canyon Springs and Damani Ranch. Welcome to Winnemucca and to Lowry High School today. We also, I have the same situation, Justice Hardesty, where the students are all to my back. I think you can see some of them in the camera shot along with some of our special invited guests this morning. We also have attending today McDermott High School, another one of our high schools here in Humboldt County. And I think we'll be joined momentarily by a couple of classes from the French Ford Middle School as well. So it's very nice to have everyone here. And I think since my students this morning were caught a little off guard with the initial introductions, I'd like everyone that's behind me to maybe have another opportunity at saying good morning to the other high schools. How about one more try at that good morning? I wish the camera could show you this. We're actually in the old gymnasium at the high school here in Winnemucca, and I think that 3/4 of the bleachers behind me are full today. A wonderful turnout. I'm very excited about that. And even more exciting today is the fact that we had the opportunity, before joining Damani Ranch and Canyon Springs, by showing these students the play that was done by the high school in Las Vegas about the Hiibel case. I think most of the students across the state that are participating today have had an opportunity to watch that. And I really hope that the students behind me today will come forward and ask some questions, because we have the honor and the pleasure of having with us today. I'm going to begin kind of an order of appearance from the play today. First, Sergeant Lee Dove with the Humboldt County Sheriff's Department. Sergeant Dove, where is he at? Oh, okay. Well, the sheriff, Ed Kilgore, is with us today too, and he just came to my right and said that Sergeant Lee Dove was called out for a call this morning, so that happens. He will be back, and I hope the students have an opportunity to ask him some questions. As you watch the Hiibel case unfold, the case then went to the Justice Court here in Humboldt County, and longtime Justice of the Peace today is with us, Gene Womble. Gene? And that course, the case then proceeded to the district court here at the 6th Judicial District in Humboldt County. And the judge that heard that appeal, that first level of appeal, was District Court Judge Richard Wagner, who is also present. Judge Wagner, when we first came into the gym this morning, he said, "I hope that someone young, tall, and handsome plays me in that portrayal of the Hiibel case," and I think they found someone to play that role very well. We also have today an individual who at the time was in the State Public Defender's Office. And this is Mr. Robert Dolan, who is now in private practice here in Humboldt County. And welcome, Mr. Dolan. Now, you may not be able to see, and I'll move my chair slightly. Mr. Dolan brought with him today a file box. I think he brought with him today a portion of the Hiibel case, so he is actually prepared to discuss it in some detail if needed. We also have here, you have on the, in Las Vegas, Judge Conrad Hafen, who handled the case, was a part of the District Attorney's Office here in Humboldt County at that time, and Judge Hafen, it's good to have you present as well. And those are the players in the Hiibel case who we watched that are here in Humboldt County. Thank you. Justice Seda, I'm going to send this back to you for a moment, and I'm going to then turn to the students that are behind me, and I'm going to ask them to please start coming forward if they have questions. And if you start to see students sitting in the chair that I'm in or the chair that's next to me here, that would be an indication that I have someone that would like to ask a question, and maybe you can break back to Lowry High School.
Thank you, Judge. Judge Freeman, Justice Hardesty, if you would make similar arrangements so that we can start lining up our students to ask questions. We have a great benefit this year in Law Day Live of having the full curriculum already presented to our students. And I will tell you, I did a little run-through with the students here at Canyon Springs on Tuesday, and they have some remarkably profound questions that they want to be asking us. We are monitoring, as I said, our electronic messaging, if you will. The first tweet that I would like to send out is, Canyon Spring wants to recognize their favorite magnet teacher, Joseph Giuliano. Let's go back for a moment to DeMonte Ranch and ask if we can start there with the students telling us what their concerns, questions, or priorities about the Hiibel case were. Do we have questions in that regard, Justice Hardesty, Judge Freeman?
Chief, we have two students that have come forward. I'd ask them to introduce themselves, and then they would like to pose a question to the collective group of us.
All right, I'm Alex Tower. My question is, when being breathalyzed at a sporting event, don't the students need their parents there, or can the school police just do that?
Justice Hardesty, would you repeat the question for us?
Question is, if you're attending a sporting event, a student is attending a sporting event, and the school initiates a breathalyzer testing of the student, are their parents required to be present as a conditioned precedent, I assume,
Yes.
To the initiation of the testing? I guess I'd like to first know, among the students here, how many, by a show of hands, think that your parents must be present for the breathalyzer to be initiated?
Good question here. How many think parents have to be present?
Fairly small minority. How many believe that your parents don't have to be present? Fairly substantial majority. How about in Lowry, Judge Montero? What is the sense there?
Well, students, have you been listening to the questions? What is the sense of the question that's been asked today? Anyone like to make a comment or give some feedback? I do have a young lady that's joined me at the table that does have a question. I think everyone else is a little shy at the moment, Justice Hardesty.
Okay, before we move on, I don't want to leave the question unanswered. I guess the critical question that I had raised earlier and asked Judge Freeman to comment about is, how would you analyze that question? Where do you begin the analysis to arrive at the answer? And there are competing interests, of course, in discussing these kinds of questions. The first is, of course, the student's right to privacy and their right to have parental access for the potential commission of a delinquent offense, at least, as opposed to the school's interest to maintain control and avoid health and safety consequences resulting from underage students drinking on campus. The real interesting question for me, though, is whether the parents have to be present as opposed to the student's privacy right to refuse the breathalyzer test in the first place. Based on that rubric, Judge Friedman, what do you think?
Well, first of all, I think we know that when you're in school, the school administration kind of takes on the role as your parent. And I think that when a police officer, given my previous definitions, believes that a student might be under the influence of alcohol, they begin their investigation. And police officers have a probable cause tool. Just like we talked earlier, they have a preliminary breath test machine that you may have seen. And that is a machine that they give to students or other individuals just to see if they have alcohol on board. And so the investigation starts with maybe unusual behavior, the smell of alcohol, reasonable suspicion. The reasonable suspicion now ripens into probable cause, where they take out the breath machine. And because you're on school grounds and a school function, and because I believe that the teachers take the role of the parent, I don't believe parents need to be present. And I think you'll be breathalyzed if you drink at a sporting event, so don't do it.
Don't worry about that one.
Okay, let's ask the student in Lowry if they would like to pose a question, and then we'll come back to the chief.
Thank you, Justice Harsty. I have at the table Robin Schaefer, who has come to the table with a question.
When we were talking about how you have to present your name if asked by an officer, how do you know that they're not lying to you? Or how can you prevent that they're not lying to you?
The question is how do you prevent the person who is providing the identification, prevent them from lying to you about their name?
Yes.
A good question there. And, I wish we had Sergeant Dove back, because I think this would be a great question for one of our law enforcement folks. And I do have Sheriff Ed Kilgore here. I think I'm going to put him on the spot. Sheriff Hiibel, would you like to come forward? I think this is a good question for one of our law enforcement. How do they handle a situation like this when there is a stop made, and if all that is required is that someone provide their name, how do you know if that person may be giving you a false name? Sheriff Hiibel, you have to kind of stand in the middle here so they can see you, and I think if you speak loud enough, everyone will be able to hear you.
Okay. We're lucky here because we're in a small community and we do know each other. We know the children, we know the families and the parents, but it's not uncommon to be lied to. In an investigation, if we find that someone has lied in giving their name, there may be an additional charge of obstruction of an investigation that would arise from that.
Thank you, Sheriff. Thank you, Robin. I also, if you don't mind, I'd like to, again, reintroduce Sergeant Lee Dove, who has returned. Sergeant Dove, we watched him in the video this morning. He's back with us here in Lowry. How everyone give him a round? Just to say, if you don't mind, I also have at the table a young man, Michael Drake, and maybe I'll let him ask a quick question, and then we'll throw it back to you.
Very good.
I was wondering if, say, your cell phone or something is confiscated on school and searched, if they find something, what are they liable to charge you with if they did find something on your phone?
And the question is if something is found on your phone while it's confiscated on school grounds, what might they charge you? I think at this time, I'm going to invite to the table District Court Judge Richard Wagner, who served as a district attorney for years here down in Pershing County. Justice, our judge, would you mind coming forward and helping us answer that question?
What have you been putting on your phone? Question is, as I understand it, what could happen if you have something on your phone that may be incriminating? Well, if it's lawfully seized, that's the whole point of the Fourth Amendment. If your phone has been confiscated legally, then they can use any evidence that results from that. And as you know, there's problems with regard to texting or what they call sexting or other things that are going on today. And people find out that they can be criminally charged if they put things there on the phone, and it can be retrieved by law enforcement. In fact, we often do search warrants as judges to allow them to go and get those records, the law enforcement, once they have probable cause to show that there may be a crime committed with them. So that's not uncommon.
And Judge, I think we have a case that might be of interest. A young man in the state of Florida a few years back actually sent some pictures on a cell phone of a young girl who was his former girlfriend that were incriminating in nature. And long story short, he ultimately pled guilty to a felony and is now required to register as a sex offender in the state of Florida. So the answer to the question is, depending upon what is found, manner in which the phone was taken, that's giving rise to that. But in the end, if incriminating information is found, such as was the case with the young man in Florida, it is entirely possible for that information to be used against you in a prosecution. So don't do that kind of stuff. I believe we have a question here in Canyon Springs.
My name is Alicia Duncombe, and my question is for the actors in the Hiibel case. It's a two-part question. Were you surprised that the Hiibel case made it all the way to the Supreme Court, and why do you think the Supreme Court took an interest in this case?
Judge Hiibel.
Justice Hiibel, would you like us to try to take that here at Lowry?
We're going to have Judge Hiibel respond, and then we'll toss it back to you in Lowry.
Perfect.
Judge Hiibel.
Well, initially I was surprised that Womble recalled the penalty after the commission struck the law. And there were several times that Nola had touched the court. It's amazing that Kate and everybody the mind going all the way to the court. So in that regard, but then, of course, we had September 11th, and I think the court, not only because of the circumstances, things that were happening in this country, but because there was still a question unresolved after the polling as to whether the person involved to identify themselves, decided that the Hiibel case was right.
Follow-up from Lowry?
I think it would be only appropriate to give Mr. Dolan an opportunity to respond as well. He's here at the table.
Good morning, everyone. I think the question was, why did the United States Supreme Court take the case, as I understood the question. Interestingly, there was a similar case that had been decided in the federal court system by the Ninth Circuit, which had looked at this very statute that was at question in this case concerning Mr. Hiibel, and the United States Court of Appeals for the Ninth Circuit found that the statute in question was not constitutional, and so the Supreme Court found itself with the situation where the highest court of the state of Nevada was interpreting its statute different from the highest court in the federal system and wanted to perhaps resolve that discrepancy. Mr. Hafen made an interesting comment about 9/11 playing a role in the psychology of this case, because the facts of this case, this was a pre-9/11 incident, but definitely did have post-9/11 consequences. And I can just remember how many different pressure organizations who showed an interest in this case outside amici or amicus groups from the ACLU to police organizations really wanted to frame the issue in connection with some of the underlying tensions in society in light of 9/11. And I believe the Nevada State Public Defender's Office at the time, and certainly I did, want to sort of take the analysis away from the pressurized moments from 9/11 and just to look at what the role the citizen has. I still disagree with the United States Supreme Court's decision, because I think now what we have is circumstances where citizens really need to make a distinction in their own mind about whether or not they are having a voluntary interaction with a police officer, or maybe they need to be a mind reader to know that while they're talking to this police officer, what they think is a voluntary interaction is actually a Terry stop, because police officers do not tell folks, by the way, you are now subject to the rules of Terry. And I always thought it was going to be a very difficult burden for citizens to know what their responsibilities as a free member of our country is. So you really do risk making a mistaken judgment, not realizing that what has happened to you is what started out as a voluntary interaction between the police officer, migrates up the scale to a Terry circumstance where there's reasonable suspicion in the mind of the police officer, and then can go up the scale to probable cause.
Quick question, if I could interrupt for a moment. When we talk about a Terry stop, we mean what?
What do you mean by a Terry stop?
Terry stop means what?
A Terry stop. Well, that's the case that was discussed in the show this morning, Terry versus Ohio, where a police officer who has reasonable suspicion that a criminal activity may be occurring can temporarily stop a citizen to investigate their suspicions. The Nevada statute at issue in the Hiibel case allowed the officer to demand an identification from the person that they were speaking with or investigating at that time. So a Terry stop is a temporary stop. It allows you to be seized without there being probable cause for a reasonable period of time to allow the officer to conduct the investigation. And also during that Terry stop, there can be a search if there are grounds to believe that you may be armed. And the search in the Hiibel case, to my mind, was the search for information subsequent to identification and all the issues about databases and the like.
And we had one tweet that came through I just want to add. The question was, it's a crime then for an officer to ask the suspect name when he is called to a domestic situation. Let's hear the student's response to that. Is it a crime or not? No, this is the Hiibel case. In fact, given that reason to be there, it is appropriate for the police officer to ask the suspect's name. Another tweet just came in that I'm going to toss out to any of the locations. When a Terry frisk is conducted, how does an officer differentiate between a marijuana and a cigar pipe?
Since I have
Mr. Savage is going to take that one. Mr. Savage.
We all have to remember that Terry frisk is limited to a search for weapons, so that you can frisk the person for officer safety, and if you feel a weapon, you can, and of course, confiscate it. But what the law says about marijuana and contraband or drugs is that if during the frisk it is immediately apparent under what we call the plain field doctrine that something other than a gun or something else that is illegal is being touched by the officer, if it's immediately apparent, he can confiscate it and you can be charged. So as a defender, of course, what we are always trying to do is to show that that it isn't immediately apparent and that the officer exceeded the scope of a Terry frisk. But there are times, many times, and there's a case called Sad and Renee Connors right out of Nevada, and it follows the Minnesota v. Dickerson case, where the courts have said that if the officer gets up and testifies that it was immediately apparent by his plain feel that he could tell it was methamphetamine and not oregano or not, powdered sugar, then certainly that seizure will be validated and will be affirmed by the courts.
We have a question here in Canyon Springs that I'm going to call for, but I just wanted to refer back to the comments that I made earlier about what might be found on a cell phone. And you should be advised that under Nevada Revised Statutes, Chapter 62, in fact, in the state of Nevada, sending what we might refer to as a naughty picture is a juvenile offense in the state of Nevada. And once you get into the adult system, it becomes a far more serious crime. But nonetheless, it is even already identified in our statute as a violation. So with that, our next question here in Canyon Springs.
Good morning. My name is Adrian Romero. Before I start, I just want to make sure that there's that regardless of lag time that there may be between both high schools, that a lot of dialogue isn't taking a while for it to be perceived over there.
Go ahead with your question.
Okay. So this is in regards to reasonable suspicion and then ultimately blind justice. It was noted by, I believe it was Lowry High School, that develop reasonable suspicion later develops into probable cause. So my question is, wouldn't the reasonable suspicion be based off of some sort of preconception or prejudice held by the police officer? And if that's the case, and if justice is blind, in cases where the Supreme Court upholds the actions of the police, wouldn't that belittle the whole purpose of our justice system, as well as belittle subsequently the rights of the individuals, of the citizens of the United States?
We're ready to hire this guy.
Yeah. Okay. The Public Defender's Office has just made an offer to my student to join their office. Let me back up a second. Justice Hardesty, Judge Freeman, I'm wondering if perhaps you might tell us what reasonable suspicion has been defined as in Nevada and the difference between PC. I know that Judge Freeman started, I thought, a very instructive commentary about how reasonable suspicion actually develops into PC. In Nevada, how do we define the difference between reasonable suspicion and probable cause?
Well, I think the easiest way to describe reasonable suspicion, and maybe even tapping into what that previous questioner was asking, it really is an issue of what the police officer sees subjectively, meaning based on his training and experience. When he comes on scene, what does he see? Now, we hope that with their training, they can take away as best they can their bias, their prejudices, their opinions, and go for training and say, well, look, I'm on scene, I see a domestic disturbance, and I want to investigate further. So when we talk about reasonable cause, he knows in this situation he's got a call. He knows that the vehicle matches the description of the call. He sees a male and female near or at the truck. And he comes on scene, he wants to ask some questions. He has reasonable suspicion. There's criminal activity afoot. That's the definition. Now, what happens in certain circumstances is maybe the individual will say, I'm not going to tell you my name. And that heightens the police officer's suspicion because he's investigating a crime. And from a common sense approach, as I used that term before, if the individual has nothing to hide, why don't he answer the question? That's one argument. The other argument is if the individual knows his rights, and we hadn't decided the Hiibel case, he's not going to answer that question. So the police officer has choices. And so he observes the entire circumstances. We call that the totality of the circumstances. And maybe something that's said or something is done rises to the level of probable cause. And probable cause is that standard where the police officer has to make a determination whether he takes the next step. And that next step could be, I'm going to ask you 11 times what your name is, and if you don't answer, I know I can arrest you. And he knows he can arrest you now. And so probable cause ripens or heightens to that level. Now you're being taken away for jail.
And if I could weigh in, Chief, reasonable suspicion is generally characterized as the strong belief that a person might have been or is engaged in the commission of a crime. It is the test that we as judges use to determine whether the police officer's common sense was correctly assessed in making that determination. It is only when the police officer has probable cause that the officer can then arrest, and probable cause is a realistic belief that a crime has been committed. I'd like to offer an observation about the student's question in Canyon Springs just a moment ago, because the coincidence of that question in relationship to history yesterday is significant. I don't know how many of you know, but yesterday the United States Supreme Court heard argument in the case of Arizona versus the United States. That case, of course, raises the question of the constitutionality of SB 1070, a statute adopted by Arizona, which, among other things, allows a police officer to inquire of an individual with whom they come in contact as to whether that individual is an illegal immigrant or undocumented individual or undocumented alien. As a follow-up to the student's question, one of the threshold issues by Chief Justice Roberts at the very beginning of the oral argument was, is this case about racial profiling? And all of the lawyers advised the U.S. Supreme Court that the arguments that they were presenting yesterday would not raise the question of racial profiling and the constitutionality of those statutes under that concept. So the student's question, by the time he gets to law school and ultimately the public defender's office, he'll be able to present that case because they waited for him to show.
Thank you very much. Thank you. Do we have questions in DeMonte?
We do. We have another question.
Hi, my name is Melissa Sheridan, and I'm going to put my question back to school privacy. And why are school situations involving privacy of the individual so different out, like in the school, than out on the street? Because my whole understanding of school is to prepare a student for the real life, so why aren't they treated as if they're being stopped out on the street, like they would in real life?
We had a little trouble hearing the first part of your question. Perhaps one of the two judges present could repeat it.
The question was, Chief Justice, essentially, if you're preparing students for the real world, why aren't they treated like that? In other words, why are privacy rights perhaps lessened in the school arena than they are out on the street?
I'll take a stab at that. First, here in Canyon Springs, one of the reasons that there is a different or a lesser standard at or on school properties has to do with what we referred to earlier, and that is that the school's role is very much like that of parent when, in fact, you are on school grounds. There is also a sense that the school has a right to protect the other students on their school property, and so at least at the very basic level, that is the reason why we treat students who are on school property a little bit differently, and we treat them like students. In preparation for the real world, this is perhaps not necessarily supported by law, but indeed an editorial comment. All the education that you receive and being a part of the classes that certainly I have here in front of me in Canyon Springs is precisely what your schools are doing to prepare you for the real world, to ask challenging questions, to understand your rights and the protections that are guaranteed to you under our Constitution. And so a strong, solid educational base is perhaps the best preparation that one can have for adult life. While you are in or on school grounds, the fact of the matter is your school district, your teachers can and should act in a role of both parent and protection of all students on campus. I don't know, Judge Hafen, if you'd like to add to that. Judge Montero?
Chief Justice, this is Justice Hardesty. I'd like to weigh in on that comment when it's appropriate.
Please proceed, Justice Hardesty.
I don't think it's wise to give the students the impression, and I'm not suggesting you have, that all bets are off in the student or in the school environment. Under New Jersey versus ATO, the court reduced the standard in the school environment from probable cause to reasonable suspicion to examine your locker, your backpack, or seize your cell phone. But what's the operative word in what I just said? The school officials must still have reasonable suspicion before they can seize your cell phone, examine your backpack, or breathalyze you at a school athletic function. So the students should keep that in mind when examining their own privacy rights in the school setting. With respect to the school or the cell phone, let me give you an example of a case that I used when addressing a class at Virginia City High School. The case is called, and I'll give you the site, so perhaps the teachers might wish to have you review the case. It's a United States District Court case. It's called Clump versus Nazareth Area School District. It is 425 Fed Sup 2nd 622. If I were the teacher, I'd be testing all of you on this case. Just a suggestion. But in that case, the school principal and the assistant principal seized the student's cell phone without reasonable suspicion. They simply seized the cell phone because they were annoyed that the student was using it. And then the assistant principal examined the student's cell phone for its contents and placed phone calls to various contacts within the student's phone. In this case, the parents brought suit against the school district, the principal, and the assistant principal for using the phone and making phone calls to the contact list. And the claim in the case was that it was an invasion of the student's privacy to have done so. The court struck the case as against the school district, but allowed the case to go forward against the principal and the assistant principal. Why? Because of the absence of any reasonable suspicion that on the cell phone would identify any acts of criminal behavior.
Justice Hardesty, along with that, a couple of things I want to toss out. I have 3 questions that have just come in from Twitter that follow your comments and certainly the Clump case. And I want to make a point here. This is the best year that we've ever had with Social Network. We are getting a significant amount of questions via our Twitter and our Facebook accounts, and we're trying to get to them as quickly as we can, so keep your questions coming. A couple of questions that are follow-ups, if you will, to your comments and my comments. I'm going to read you the series of questions that I believe can be answered in one response. Is it legal for school administrators to check a student's cell phone at any time and run them through some type of FBI check? Question number 1, obviously 2 parts. Where in the Constitution does it say that they can search my phone without consent? And isn't searching through our phones an obvious invasion of privacy under the 4th Amendment? And finally, can police bring canine dogs without our knowledge to check lockers? All of which sort of fall into the same line of questions. I don't know, perhaps Judge Hafen, Mr. Jordan, Mr. Savage?
Well, a couple of responses. First of all, the 4th Amendment clearly gives us privacy rights, but those privacy rights are not absolute. We have exceptions. The United States Supreme Court and various state Supreme Courts have delineated those exceptions. You have an exception to your automobile. If the officer has probable cause to believe that there's contraband in your automobile, he can search that car without a warrant. So privacy rights are not absolute. In regard to searching the cell phone, again, the teacher or the administrator would have to have reasonable suspicion. that that cell phone contains evidence of a crime before they could search it. So let's don't lose sight of that. They just can't grab your cell phone for any reason and search it. There's still that reasonable suspicion. And as Justice Hardesty pointed out, it's a lower standard, but it's still a standard that the administrators have to meet before they can search.
Can they run it through whatever they find? Can they run it through some type of an FBI check or an NCIC check, something of that nature?
Well, I think they could if they had reasonable suspicion that there was evidence of a crime on the cell phone.
So that lower standard of reasonable suspicion gives them the right to do that?
I think it does.
Mr. Savage, you agree?
I would, of course, take the opposite position, that it would only allow, in certain circumstances, reasonable suspicion would only allow you to seize the phone, and to go any farther would require a heightened degree of constitutional scrutiny. But I certainly agree with Justice Hardesty that we need to be sending the students the message that it's not carte blanche, that there's a lessened expectation of privacy in a school, and that we do have this tension between the school's obligation to protect students and to run a school system and individual rights. And how we define that tension is always going to be a matter of interpretation for the courts, but individual rights still do exist. They just exist at a much lower level, and the reason is that we have a far less, or you students have far less of a reasonable expectation of total privacy in a school setting as opposed to the street or a home.
Thank you. Judge Montero, let's go back to Lowry. Do you have some students with questions?
They're lined up here, so let me just immediately turn to our first student who's been sitting here for a long time. I think it's David Gleam, is that correct?
It's actually Galiana.
Galiana? David, go ahead.
It's kind of a two-part question. From what I gathered from previous statements is that probable cause is a subjective matter, because what seems incriminating to one officer might be completely normal to another officer. And I was wondering if there was a better way to handle things without bringing probable cause into the matter. And a second question, if I may, is an officer can take your cell phone if he thinks you're doing something illegal with it at school, if he had like the probable cause or reasonable suspicion. So if the officer has reasonable suspicion or probable cause to take your cell phone, my question is, it is against the rules to use your cell phone during class. So if you're simply using your cell phone during class and there's nothing really illegal going on, they take your cell phone, can they search it? Because I think that a cell phone falls under intellectual property, which is protected by the Fourth Amendment, if I'm correct. And that's my question.
Justice Sayer, that was a lot there. Justice Hardesty, would you like to weigh in on that?
I would. If there is a rule in the school that you're not allowed to have your cell phone in class, then the school official taking your cell phone is perfectly permissible under the rules of the school and under the concepts that the school is your parent, and as was suggested by Mr. Savage, the weighing between the school's interest in controlling the environment, the learning environment, weighed against the student's privacy interest. In that case, the school wins that weighing test. The phone can be obtained. The second question, and it is an independent question, can the school official then examine the phone for its contents? Without reasonable suspicion of some criminal behavior, the answer is no. But let's suppose this hypothetical in response to your question. What if a classmate reports to the teacher that you have been engaged in sexting, and the reason for obtaining your phone is to examine not only the phone but its contents? That could be a reasonable suspicion for examining the telephone or the cell phone.
And I wanted to weigh in a moment on the question related to, can we do away with probable cause? And the answer is we cannot. Because to follow up Justice Hardesty's question, when you, or his answer actually, when you look at the cell phone and there's a reasonable suspicion there's sexting going on, and the school administrator has seen the phone and sees the image, you have now entered the land of probable cause. And by way of looking at that image, then the police will take action. So there is no way to do away with probable cause from reasonable suspicion if it goes in that direction.
Judge Montero, other questions?
Well, let's just quickly, Judge Wagner has asked to respond briefly.
I think there's this is Judge Wagner, I think there's a major misunderstanding that the standard is subjective in court. As judges, we use an objective standard that under the totality of the circumstances, whether or not a reasonable person would believe there is probable cause. This is not every officer is free to do what he thinks is right or wrong. There is an objective standard, and we spend hours and days and months trying to determine that. And that's what happened in the Hiibel case, frankly, is that analysis of what is truly under an objective standard.
And Justice Ada, let me turn it over to Dusty Theed, who has a question as well. Dusty?
Yes, the school has authority over us while we're on school grounds during school time, but does their power over us extend to off campus during school time, on campus off school time, and since I'm over 18, would they still have power to take my cell phone even though I have rights as an adult?
Justice Ada, if you don't mind, I'd like to, if the bells don't interfere too much here, I'd like to see what some of our students in the audience might think, just maybe by a show of hands or response. How many of you think that the school still has some ability to control what you were doing if you're on school grounds after school hours? How many think that they may still have the ability to do that? How many of you think, no, the school loses that ability? How about if it's during a school event, but it's not during school hours, like during a football game or a baseball game? You think the school still has some ability to probably take your cell phone or question you? Well, you know, we're getting a pretty split response here. I think it's interesting to see some responses from the students. Justice Ada, thank you for allowing us to do that. And Dusty, thank you for the question. I think that maybe in brief response to that, I think it's very fact dependent. I think it depends on what is occurring at the school. If it's during a school event, the school would still have the ability and that authority to question you if there is, again, we have to get to that reasonable suspicion standard. And then an interesting question here about what happens, is there a difference when a young man or a young woman is in school still and they turn 18? I think another good question that's been asked here, you're still a student, you're still under those same requirements to follow the school's policies and procedures, and the only difference is that the laws that apply to you may be different. And I think just by way of just a real brief plug, there is a very nice magazine that's put together by the Washoe County Bar Association that outlines what legal changes occur when you transition from 17 to 18. I know I recently handed some of those out to some students, and I think it's very significant differences. You're suddenly treated as an adult now if you're 18, and I think can have a real impact. We have some more here, Justice Ada, but I don't want to consume the time. Do you wish to have us turn to one more student, or do you have someone there?
Please let's take another question from Lowry, and then we'll go to DeMonte.
One more question at the table. Young lady, if you'd please identify yourself.
My name is Rebecca Maston, and my question was, if in the Hiibel case, when it was originally about suspicion of domestic violence, why did it then turn to something else instead of the officer asking other questions of the people around that would have had information about the domestic violence rather than just asking for identification?
Justice Ada, if you don't mind, I have Sergeant Lee Dove, the individual who actually made that arrest, and he's going to respond.
Couldn't be better.
In the Hiibel case, one of the things I'd like to clarify on is that arrest was not made of Mr. Hiibel based on his failure to identify himself to me. The arrest was made under the 199 code in Nevada Revised Statute for obstructing and delaying an officer. And then the case proceeded through the 3-4 court system based on the work of Mr. Dolan. In that particular case, on that on that call for service, domestic violence, obviously in the state of Nevada, is taken very seriously. I met with the reporting party in a vehicle who specifically pointed out Mr. Hiibel and Mimi Hiibel in the vehicle and physically identified that vehicle. He also directed me to the car, the truck, and I went to the truck. What transpired is at that point is I'm planning on going into a domestic violence investigation, which I'm required to do by Nevada statute. Unfortunately, we never got that far because Mr. Hiibel, as you clearly saw, or have seen, I hope most of you, did not want to provide his name to me. So at that particular point, we've got an obstruct and delay charge that is preempting the domestic violence investigation, and so he was subsequently arrested on that. What may not be known prevalently to everybody is, in fact, domestic violence charges were filed based on a written statement that was provided by the witness, and unfortunately that witness was unavailable to testify in court, and those charges were ultimately dropped for domestic violence.
So the domestic violence then was investigated further rather than...
The domestic violence case was investigated further. We were obligated to determine a primary aggressor, which was Mr. Hiibel, and the statement provided by the original reporting party supported that. However, based on the totality, and again, the totality of what we had, and based on work between the defense and Mr. Hafen as the prosecutor, there was a lack of sufficient evidence and a lack of availability of a witness to continue with the prosecution towards that. So that case went away, and subsequently we've continued with the case concerning his failure to identify me.
Okay, thank you.
Thank you both. Justice Sater?
One of the follow-up questions that has come into us via our social network has to do with a bit of a shift. And I know that this was at least part of some of the underpinnings of Hiibel. The question is, can someone take advantage of their Fifth Amendment right and choose not to talk at all because talking at all may be incriminating? Judge Hafen.
Well, that was the issue that Justice Kennedy addressed in the Hiibel decision. And in regard to identifying yourself, the answer to that is no, that it's not self-incriminating. Of course, compelling somebody to answer any other questions relating to the investigation would be a violation of the Fifth Amendment, but as it relates to identifying yourself, the answer is no, it doesn't violate it.
Chief, I'd like to weigh in on that, if I may.
Of course.
The question is whether that holding in Hiibel would now be the same in the Arizona versus United States case, where the individual who identifies themselves under the Arizona statute dealing with illegal immigration, that now provides the information base or the information that's used to contact the federal immigration database to determine whether this individual is an undocumented alien. I'd ask the defense bar, the defense lawyers here, whether they think that the individual who responds in Arizona to that question it would be a violation of their Fifth Amendment right, and did Justice Kennedy get the second part of the Hiibel case correct in that context? Maybe Mr. Dolan or Mr. Savage would weigh in.
Justice, that's a very interesting question, because unlike Hiibel, where it appeared that the facts of Hiibel were that Mr. Hiibel was just not being cooperative, it appears that the argument in Arizona, and correct me if I'm wrong, is going to be that merely giving a name could be very, very incriminating under the facts and the immigration objective with that law. So I think it's going to be very interesting to see whether, and we know that Hiibel was a 5-4 decision. The court's a little different today as to how they will do that analysis, because that's the distinction that I see between Hiibel and the immigration case is that merely giving a name when you're looking at deportation is very incriminating, whereas for Mr. Hiibel, the mere giving of a name under those facts probably was not.
We have
Step in here just for a moment, too.
The actual holding of the Hiibel case by the United States Supreme Court said in that particular case it was not incriminating because the defendant never alleged that it was incriminating. But they also held there might be a case where simply giving your name is incriminating, and in such a case they determined they were not deciding that case on that day. Every case is done case by case, but Hiibel really has an opening which could, if it's truly incriminating by giving your name, you still have a Fifth Amendment right. That's how I read the case.
We have some student questions here in Canyon Springs. Sir?
Thanks, Judge. Hello, my name is Manny Griffin. In the Hiibel case, perhaps the main argument from the state was that providing one's name is an inherently neutral act. However, my question is, where do we establish a bright line as to what else could be considered neutral, such as providing your email address or your address?
Well, that's a great question. I know in the argument, Justice Ginsburg asked me if the statute could be interpreted to also require somebody to give the Social Security number, date of birth, those type of things. My response was no. The statute only requires that they identify themselves. In regard to your question, I think it just comes down to you have to provide your name to the officer once he has reasonable suspicion that you are engaged in committing a crime. Okay?
Do we have questions in DeMonte? At DeMonte? Questions at DeMonte?
We do.
My name is Samantha Edmondo, and my question is something like a Facebook profile, which is public, should a school official stumble upon something that would be that could be a criminal charge, do they have to get a warrant in order to search the Facebook page, or is it because it's a public entity, can they just search it and use that evidence against the person?
And I'm going to add to that question before our experts answer it, because there are several questions similar to that have come in via our social network. Can school officials search your car on school property due to an incident that happened in school? Same thing about your locker. Somebody happened to find your locker. Can they now go to your car? And there's the rest of the question. Can hearsay, I'm sorry, can hearsay be used to support probable cause or reasonable suspicion? Judge Freeman?
I'll be happy to answer that. First of all, on your Facebook page, if you put it up there, you better believe everybody's looking at it. That's the first thing. The second thing is absolutely, hearsay is an out-of-court statement used for the truth of the matter asserted, which is a legal way of saying you heard it from somewhere else. Because you're not in court, which is a hearsay rule, of course police can hear from somebody else that somebody else said something else that said something else that leads to reasonable suspicion. In fact, some people believe that's good police work. They'll talk to one of your friends or somebody who's not a friend, and they'll say, what do you know about so-and-so? And then the police officer will take the ball with that and do further investigation. So you absolutely can use hearsay, and when your Facebook profile's up there and you're saying interesting things, you better believe everybody's looking at it.
And if I could add, Chief, the fundamental point about the right to privacy is that you have an expectation of privacy. When you post things on the Facebook, you lose that expectation of privacy. And that provides a basis for proceeding if there is some criminal behavior posted without involving Fourth Amendment issues.
I'm going to take just a moment and shift our attention, if you will. We have talked for about the last hour and 15 minutes about identifying certain of your rights, being cognizant of the breadth of a search, that is how far a school official or a police officer can go in effectuating a search. One of the things that we are concerned about today in Law Day is even the most eloquent Constitution as far as I'm concerned, is worthless if you don't have anyone to enforce it, you don't have anyone to analyze it. Judge Wagner, I think most importantly, pointed out that we have the assessment of a police officer on the street, we have the assessment of a prosecutor who brings the case, and then you have the final arbiter, presumably your judicial officers, who determine whether or not the conduct of all involved was reasonable. But the question is, if our courts belong to everyone, and that is the place that you go, if you will, as an emergency room to resolve these questions and these issues, what will happen if our courts are no longer open or accessible to litigants, or at least not as accessible as they always have been in the past? The fact of the matter is that we have judicial roles that have not changed. The judges are supposed to analyze the actions of the police officers, allow appropriate evidence to go before a jury to determine guilt or innocence of the party accused. And yet, in these difficult times, our court staff and courts all around the country are suffering from very serious budget constraints. Is it okay to curtail certain court activities simply because there isn't enough money to run the courts or to keep them open and accessible? Or is that a violation of your constitutional rights? Judge Montero?
Just by way of a little background there, as you talk about this issue of access to justice and the availability of justice, I think here in rural north central Nevada, we're pretty fortunate. We haven't been faced with some of these cuts, these economic setbacks that I think courts are facing in other parts of the country. However, I do know and I am aware of how this has impacted some courts, and actually some courts here in Nevada, and where there have been layoffs or positions that have not been filled, and it might delay an individual's ability to have their case heard. I do think that is a significant concern as a judge as to what happens if that trend continues. And if that continues in this way, if we're going to have, say, less staff or fewer judges or fewer hours where the courthouses are open, and then people's cases aren't being heard in a timely fashion, I do believe that could create some significant problems across this country to those who depend on us to provide that service in these communities across the country. Now, to what extent that becomes a constitutional issue, I think time may tell. I think it's an interesting issue that we will be following as judges across the state of Nevada and across the country.
Justice Hardesty, is justice in jeopardy as far as you're concerned with respect to fiscal considerations, backlogs growing, criminal trials being delayed? Is justice in jeopardy?
I think across the country, the statistics demonstrate that justice is in jeopardy. In Reno and in Clark County, I would offer some statistics that suggest that it is clearly in jeopardy. Let me offer these points. And most of the students who might get a traffic ticket, or you might end up in some kind of preliminary fracas, you're going to be going to, if not the juvenile court, you're going to be going to a municipal court or a justice court to deal with those kinds of problems, right? Okay, so here's the deal. In Reno Justice Court, 17% of its workforce has been cut in the past 4 years. In Reno Municipal Court, 9 of 49 staff positions were abolished during the past 3 years. In Las Vegas Municipal Court, 1/4 of its staff has been eliminated because of budget cuts. Callers typically are on hold for an hour before talking to a customer service representative in the Las Vegas Municipal Court. In the District Court in Clark County, 39 positions have been abolished, and they have created 50 additional vacant full-time positions. In the Justice Courts in Clark County, 13 positions have been abolished, and 8 vacant positions have not been filled. And in the District Court in Washoe County, staff positions have fallen from 190 in 2008 to 161 in 2012, but of that 161, 10 also are vacant. The point I'm making is that in the absence of the staff to prosecute your cases, to process your cases, you will face a delay in justice. If you are, for example, a young person who's arrested and your case involves a juvenile offense, you will still face this same problem because of the press of business in the juvenile courts and the limitation on staff there. So as a citizen in our country, and you are all citizens and have a right to comment on this, is it acceptable to you for the courts and your access to the courts to be delayed because of funding limitations in our government? Do you think your constitutional rights are impaired when the courts have to make these draconian budget cuts and can't get to your case for days? Does that concern you as a citizen?
Show of hands.
How about
Let's
in
start
Lowry?
here in Lowry. Are you concerned about whether or not a delay in getting to court affects your constitutional rights? Show of hands. How many believe that fiscal or budget cuts, draconian as they've been described, are affecting your rights and your access to courts?
Would you like to raise your hands, if anyone? Think so? Okay, we have a few hands, yeah. I'd say maybe a quarter of the students here, Justice Ada. Justice Ada, you want to poll the other students? I also have Judge Womble has approached the podium and would like to address this particular issue too when you're ready.
Very good. Let's hear from the judge.
Thank you, Chief Justice. I don't want the students to get the wrong impression. In justice courts, I have an obligation to see a person who is arrested within 48 hours of being arrested and make a determination as to the probable cause. Once the person is arraigned, which is in a day or two shortly after the first appearance within the 48-hour period, a person in the state of Nevada has a right to have a preliminary hearing on a felony or gross misdemeanor charge within 15 days of their arraignment. And on a misdemeanor charge, the court is obligated to give that person an opportunity to have a trial within 60 days of their plea of not guilty. So I don't want the students to think that the financial situation is bleak to the point where justice courts are shying away and looking away from the defendants.
Judge, Judge, if I could comment on that, I'd like to get your perspective. Is society in jeopardy because the courts who are not able to meet those time frames result in the cases being dismissed and the defendant being released?
Give me that question again, please.
Is society in jeopardy if the courts are not able to meet the time frames that you've identified and the defendant is released because of it?
Well, I think society is hurt by it, yes. I believe they are.
So in other words,
I recognize... Go ahead, Justice. Go ahead, I'll withdraw.
Well, let me say this, Judge, for just a moment. You think about the bigger picture. And the bigger picture is that justice delayed is justice denied, which means that judges are the series of checks and balances for the questions that we've been talking about today. Who checks the police? Who checks the school? Who checks the administrators? Who does the objective analysis that Judge Wagner talked about earlier? It's the judiciary. It's the courts. And so if our justice of the peace in Winnemucca does not have the court staff to follow the timelines that he talked about, which were so important, then everything stops. And we don't have a system of justice where people can say, hey, wait a minute, that wasn't fair. Or was that fair? Because nobody's going to have the opportunity to check it. And then that's where we have to question where society would be.
Judge Hiibel,
well, Judge Freeman also as just a brief addition to that, and maybe this goes back to Judge Womble, what happens if you don't meet those deadlines? Do we have individuals who may have been arrested who are now set free as a result of these time frames not being met.
Well, and I think that would be a defense attorney's challenge and argument to the district court and perhaps even in the justice courts. But even today, we have the opportunity with technology. We're in 3 different locations, so technology is a very key to what we do as judges. I think the technology affords us the opportunities to have briefs that are filed through CDs rather than through paper. Some federal courts do that. So I think there are many opportunities that we as judges have to look at to see how more efficiently we can work with fewer dollars.
A question just came in on social network that ties to what we're talking about. It's been answered at least in part, but I want to make it clear. This is the question. If a kid is arrested, will they spend more time in detention now, given budget concerns? Technically, the answer would be presumably no, but I'd like to hear from an urban court about whether or not you have the same luxury of being able to get to your 48-hour hearings in a timely manner, and what happens if you don't?
Well, in Las Vegas Township, each judge has a week where they're on call. I go down to the jail on my week on a Saturday, and I do all the 48 hours. But then those 48 hours are coming in every day to each JP. And so we're reviewing all the arrest reports for probable cause within 48 hours, and then they're brought over for their 72-hour hearing for their initial arraignment. Where we're seeing difficulties is the Clark County DA's office doesn't have the ability to file a complaint on time. So a lot of times we're administratively ORing defendants because the prosecutor is asking for 120 days to file a complaint. So those people are getting kicked out of jail, and then they're given a return date to come back in 120 days. But in addition, another problem that we're having down there in Clark County, at least in the Justice Court, is the ability of defendants to be able to pay their fines. And I'm constantly asked, can I do community service in lieu of the fine? And the response that I get from other judges and from court administration is, that's fine to do that, but don't waive our administrative assessment fee of $177. And with a lot of defendants, that's still a problem to come up with that $177 administrative assessment fee, and so they want that waived in lieu of the community service. And so that really builds up a tension, at least in my court, because I do the DUI court, and it's one of the busiest courts in Las Vegas. And we have a lot of people that cannot afford any money toward their fine, and so they're constantly asking for community service, but then that takes away from money that the courts can use to hire people to do things and run the court properly. So it is an issue.
Judge, you used a term that goes to a form of release. When someone is arrested, they can be released in a number of ways. You talked about an OR, an own recognizance. Can you briefly explain to the students what that means?
Well, what happens is when somebody gets arrested, there in Clark County, they go through what we call pretrial services. And those folks will ask them a series of questions, and if they meet a standard, then to alleviate the overcrowding of the Clark County Detention Center, they will be administratively OR'd at that point and then given a return date. When they don't meet those standards and they're brought over for their 72-hour hearing, then if there's not a complaint filed by the district attorney's office, then typically they are released on what we call OR, or their own recognizance, and then they're given a date to come back. And typically it's 120 days because the prosecutor is saying, we just can't get our chemical person to analyze the blood or the breath in time in order to file a complaint. We need that 120 days.
So a bad guy gets to be let out simply because there isn't enough staff to process the case.
Absolutely. They have one person, and I'm told this every day, they have one person that has to calibrate and do all the checking of the machines, not only in Clark County, but Lincoln County. I think she goes over to Nye County, and they just cannot get their complaints done in a timely manner. So we have no choice but to OR them.
I'm told that we have students at all of our locations who are anxious to ask questions, and that's really what we're here about today. So I'm going to move quickly among and between the sites. I'm going to alternate one question and a quick answer, one question and a quick answer. I'm going to toss out one that came from our social network to start with. It is I think an interesting question. Can a student be suspended for putting a personal opinion about a teacher on Facebook? Anyone want to volunteer to answer that? Judges?
The overwhelming response here at Lowry seems to be no because of free speech.
So another amendment being implicated. Another First Amendment right. How many in Canyon Springs agree that they can't do that because it's your First Amendment right to post on Facebook? Wow, almost full complete majority here in Canyon Springs. How about at DeMonte?
For putting an opinion about a teacher on Facebook?
Should a student be suspended? What do they say in DeMonte?
In DeMonte, they generally agree that they can't be suspended, but a couple of students correctly observed unless it is threatening and creates a different set of circumstances and analysis. Good job.
Excellent, excellent. Let's take one question now from DeMonte.
Hi, my name is Brooks Syme, and there's been a lot of talk about what exactly constitutes reasonable suspicion and probable cause. And my question is, in schools, is the focus more on individual freedom or public safety when it comes to laws regarding those things?
I think
the question is whether or not on a school campus the measuring tool, if you will, the standard is protecting safety or protecting individual rights. I think, if I stated that correctly. Response
I think
from
that
DeMonte?
is I think that's the balancing test that is applied in all of these circumstances, and I would argue that post-Columbine, more times than not, the weighing will weigh in favor of the school.
Judge Freeman, you agree?
I do. When you take these cases on a case-by-case basis, it really is what are the facts. So, for example, maybe if you make a comment about a teacher that they're not a good teacher, well, I think you can say that. But if you say, I'm going to kill that teacher, now you've changed the facts. And then safety yields to privacy.
Disagreement here in Canyon Springs? Judge Hafen, Mr. Savage?
I would just ask everybody if everybody's been following the news, and a member of our military just got discharged because of making comments about President Obama. I think it was on the news yesterday. Of course, there are different concerns there because it's a military setting, but the same concept.
No, I agree with Judge Freeman. It really is a balancing test, and it's going to be on a case-by-case basis.
We'll take one question from Canyon Springs. I'd like to have someone who has not asked a question yet ask a question, if you would, please.
Hi. My name's Evan Pacheco. My question is that if a student obliges to give their cell phone to a school official, but yet takes out the battery in order to keep the contents private and to protect themselves from self-incrimination under the Fifth Amendment, is the school allowed to punish them even further for doing such action?
Judge Hafen is chuckling. Go ahead.
Well, again, and we're repeating ourselves, but I think that if the cell phone is being given up on a consensual basis, okay, there's no reasonable suspicion, and you're just consenting to do that, to hand it over, I think you could remove the batteries from the cell phone, okay? But if there is reasonable suspicion that there's evidence of a crime on that cell phone, I don't believe you'd be able to do that because that kind of defeats the whole purpose.
All right. Thank you.
Thank you. How about a question from Lowry?
Very well. I have a couple of students at the table. Go ahead and identify yourselves. I think we'll start right here.
Hi, my name is Eamon Izinga. Reflecting on a previous topic that we discussed, if there is reasonable suspicion involved for a search, can the search be postponed until a parent, guardian, and or legal representative is present?
I think Justice Hardesty, didn't you address this question a little bit earlier, I believe? Or something similar?
I think so. Yes, I believe so.
And in order for us to allow student participation, if the question has been asked and answered in a different format, I'm going to ask our experts to simply briefly state it's been asked and answered, it falls under this analysis. So, Judge Montero, do you want to take a stab at that question, briefly restating the answer?
Yes. Again, the question is, as I understand it, do you need to have parental consent before that search can be conducted? And I don't, Justice Hardesty, I think we were shuffling students in and out when you responded to that earlier. I don't remember the response that was given, but I believe that it was the response was that the student, if the student was underage, that it might depend on the circumstances, but that search could go forward. Justice Hardesty, did I correctly understand what you responded to earlier?
Yes, that's correct.
Thank you. And we have one more question here at the table. Can we ask that one before we move on? Go ahead.
My name is Carly Evitz, and my question is, say an officer asks you to identify yourself. Do you have a right to ask them before you answer that question to identify themselves to make sure they're really an officer or not?
Oh, great question. I don't know if you all heard that, but the question was, if an officer asks for your identification, can you respond accordingly and ask for their identification? And Sergeant Dove, has that happened to you?
Yes, sir.
And what do you do?
Generally, across the United States, it's a standard practice for law enforcement entities to have policies and procedures in place for their department. Sheriff's Office, state police, any organized law enforcement entity. So in that particular case, for example, within our community, the Humboldt County Sheriff's Office, I am obligated under a general order, which is directed from my sheriff, Ed Kilgore, under Sheriff Curtis Cole. I'm obligated to give that information to you. When that takes place, you need to understand that depending on the circumstances, if you may be delayed in getting that information because I need to take care of my safety or take care of the case or the event at hand. However, that would come with the form of a business card. Would come with
We're having a very hard time hearing from this location. If you could please speak up. We can't hear you almost at all, at least here in Canyon Springs.
Sorry about that. Let me just take it back, and Sergeant Dove was stating that they have policies within the department that they are to provide identification, and so that they are required to do that. Although it may be sometimes delayed if the officer is concerned about their safety, and they must address their safety concerns first. One more quick question here, Justice Seda, and then I'll turn it back to you. If you identify yourself and answer the question.
You bet.
My name is Daisy Clark, and I really hate setting you back a little bit, but I was really wondering, what is considered your probable cause or your suspicion on a student? I mean, I have been searched before, and honestly, I don't see how there could have been suspicion. I was in class just using the restroom, and I was yelled at, my phone was searched, my pockets were searched. I had no right. I asked for my parents. I wanted a female cop to come search me, but no, I got none of that.
Let's see if we can restate this briefly. The question is again, going back to that definition of reasonable suspicion and probable cause in a personal situation that may have involved this young lady, and I don't want to address that because I have no idea about those specific circumstances. But again, we get back to this issue of whoever is conducting that search has to have some reasonable suspicion. If it's questioned, that's where the courts come into play. If this matter were to proceed into the courts, then the judges would have to make an objective analysis or have to objectively review that to determine if the person who conducted that search had that reasonable suspicion or probable cause. And another area that we haven't really touched on a lot is at what point does that require a warrant? I'm not going to offer that right now, but I think that we briefly addressed the question that was asked.
Thanks,
Justice
Judge.
do you want some more from here, or do you have something there?
We're going to take a question here at Canyon Springs.
Okay. Considering the decisions that have been made in the name of safety and in the name of upholding our laws when it comes to illegal drugs, how far are we willing to give up our rights of privacy, like the Terry cases have gone, or the Terry case has gone, for safety or upholding our laws such as that? Does that make sense?
Briefly restated, the student is asking how far are we willing to go in the name of protection or drug-free campuses as against the very precious rights of privacy. Mr. Savage, could you respond to that? It's a policy question, very good question.
Well, I think the answer to that is in our post-9/11 world, courts throughout the country are willing to weigh in favor of public safety and interpret the Fourth Amendment a lot more narrowly and against individual rights. And that's why our office needs a lot of young advocates to help bring these courts back to an emphasis on individual rights.
I'm going to ask a follow-up. Don't go away. Does that bother you?
Yes, it does.
How do you feel about that?
I feel like that the reason that we originated was so that we had these individual rights, and if we're going to slowly take them away, we don't know how far these individual rights are going to be taken, because it's slowly diminishing, in my opinion, and I don't want to grow up in a world that means I have less of the right than the people when our founding fathers created the Constitution and these rights that are supposed to be given to us.
Thank you. Thank you very much. We'll take one more question here at Canyon Springs.
Hello, my name is Mariah Robinson. Okay, so according to school policy, a student must acquire their immunization shots and prove their records. So I was just wondering, can a student reject this policy under their First Amendment right and their freedom, by their freedom of religion and also by the freedom of privacy, and still attend school?
Interesting question. Can you be forced to have, I presume, and show proof of immunizations, or is there a constitutional right that would protect you from giving up that information? Sub-question, if you don't give it up, can you still attend school? Is that your question?
Yes, and if you don't even get them, can you still attend school?
Okay. Justice Hardesty, want to try that one?
Well, I haven't researched that question, but because the school is doing it, I suspect their attorneys have. I would think that as a matter of public safety, or at least safety within the schools, again, applying the same weighing factor that we have discussed before, the constitutional right to avoid immunization is not going to be upheld, and you would have to submit to the immunization in order to have access to the school. The interesting part of that question also is most students are required to go to school under state law. Could they seek reasonable alternatives such as homeschooling and the like and avoid immunization? And because of those alternatives, that might provide some exception. I also wanted to add to the student who posed the question in Lowry about reasonable suspicion. As Judge Wagner correctly pointed out, this is an objective analysis, not a subjective analysis, but it is tethered by a very important phrase, and that is reasonable knowledge. That is reasonable knowledge of the person who claims to have reasonable suspicion in order to effectuate a search.
Thank you. How about some questions from DeMonte?
Sure, we
Students
have
waiting
one.
in DeMonte?
Yes, we do. Go ahead.
My name is Jeff Ryder, and I kind of wanted to just pose a bit of a situation about reasonable suspicion and its relation to judgment. Let's say a student reported that I had substances in my car, illegal substances, and the administrator and or police officer then comes to make contact with me to hand or assess the situation with me. Without knowing that the student who made the report was being truthful or not, who is to determine the extent to which I should be searched or seized? And in other words, how could it be okay for the reasonable suspicion to now be based off their judgment of me?
That's a very good question.
Judge
May I respond?
Absolutely.
Yes. Well, first of all, that's a very good question, because first of all, you know whether you have drugs in your car or you don't. So when the police officer comes up to you and says, I'd like to ask you questions about drugs, now he has reasonable suspicion because maybe a student has told about you. you might want to decide at that point, I don't want to answer his questions, because in answering his questions, you could be incriminating yourself. And so that is where we have an interesting point where the Fifth Amendment, your right to remain silent, your privilege against self-incrimination, comes into play when you're being asked an incriminating question at school. And I would think if you chose to, you wouldn't have to answer his question.
If I could add to your question, this gets back to the point I made earlier. Reasonable suspicion, even though it's a lower standard, still requires reliable knowledge. It probably wouldn't be the first time in school history that a student with whom you have some disagreement falsely reports that you have drugs in your car. The question that is going to be in front of the judge ultimately is whether or not the school administrator or the school police made a reasonable assessment of the reliable knowledge that they had that forms the basis for reasonable suspicion. In the absence of that reliable knowledge, they may not have reasonable suspicion.
Let me add to that question for Justice Hardesty and Judge Freeman to respond to. Assuming that an arrest arises as a result of that conduct, is the person detained or what happens? I mean, we're talking about rights. I guess I want to get down to some of the reality of what happens. While some of this can be tested in a court of law, between the time that the arrest takes place and the matter is tested by a neutral fact finder, is there something that our students need to be concerned about? Detention?
Well, Justice, if I understand your question, it's what happens to a person after the police officer makes the determination to arrest at school?
Yes.
Well, they're detained, and if a crime is determined to have occurred by their investigation and the reasonable suspicion ripens to probable cause for arrest, they're arrested, detained, and at least in Washoe County, they're taken to the Jan Evans facility for processing. And when they're taken to the Jan Evans facility for processing, then they're going to have a hearing. And as Judge Wumboldt talked about earlier, there's time constraints related to being in front of a judge. So there is going to be time when you're in jail in the Washoe, at least in Washoe County, in our Jan Evans facility, waiting to see that judge. And that goes back to your point, Justice Seda, that if justice cannot be afforded financially, then the question is how long does that student remain in custody before they see a judge?
And in fact, the young student at Lowry who mentioned that his age is 18, he would go to an entirely different facility. Is that a fair statement? He would go to the adult facility?
That's right. The difference between turning 18, as Judge Montero said earlier, with the guide that's at least provided here in northern Nevada, is that you become an adult. And when you become an adult, even though you've never been in trouble before, you go directly from school, not to the juvenile facility, but you go to, in our situation, our local county jail, where you're with adult offenders. And when you're with adult offenders, you're mixed in with adult offenders. That's a very, very scary experience. So magically, when you go from 17 to 18, those are very real concerns. And the crimes are different in the juvenile system than they are in the adult system. And again, the time constraints that Judge Wumboldt talked about are different in the adult system as well.
Justice Seda, we have a comment here at Lowry from Mr. Dolan on Fifth Amendment.
Yes. With respect to the Fifth Amendment question and the conversation that a person is having with a police officer, in the Hiibel case, we were concerned about a concept about how the name provided a link in the chain of evidence against Mr. Hiibel. A half hour or so ago, you heard Sergeant Dove talking about that he was there investigating a domestic battery case. And we took the position that the name of the defendant, the suspect, if it was the same name as the victim, in this case Hiibel, that the fact that, for example, Mr. Hiibel, had he identified himself as I'm Dudley Hiibel, and Mimi Hiibel identified herself as Mimi Hiibel, Officer Dove would have been able to testify at trial to prove the case of the family connection between the two, thereby giving the government evidence to convict Mr. Hiibel, evidence that was uttered from his mouth. What was infuriating to me in connection with the order from the Supreme Court was that there was a comment that we did not raise that issue in our briefs, and I have evidence to that effect in front of me where certainly we argued specifically, thus the name furnishes not only a link, it is the very first link in the evidentiary chain of domestic violence laws from which multiple negative consequences can result.
Thank you.
So,
Thank you.
I'm still litigating the case, and I'll end right there. Thank you.
Thank you. We've got precious minutes left. I'm told that we have 2 students in each location who want to ask questions, so I'm going to ask our responders, our experts, to please keep their answers as short as they possibly can. We'll take one here in Canyon Springs quickly.
My name is Erica Chapman, and I have a question based off of a quote by Thomas Jefferson, in which he stated that equal law must be protected, and to violate the equal law would be oppression. So I'm asking, is there a time when asking for a person's personal information is an oppression of that Fifth Amendment right, and when taking personal property by unlawful force, be it police or other official, a violation of the Fourth Amendment?
Mr. Savage, how about or Mr. Hafen, either one.
Well, clearly in the Hiibel situation, the courts have ruled that the answer to that question is no. But as Justice Hardesty pointed out, in the immigration case, it may very well be a link to prosecuting that individual. So again, I think it comes back to what are the facts and circumstances surrounding the case. And Jefferson's comment or the quote that you made from Thomas Jefferson, I think that's a general principle that we apply. But every case stands on its own merits, and you're going to have to apply those principles individually to those cases.
And you'll recall when we started our discussion today, we talked about a constitutional right that has existed for hundreds of years. But the fact of the matter is that in your courtrooms every day throughout this state and across the nation, the law is evolving. And every day that technology changes and circumstances change, so too must the law. So thank you. Thank you. Do we have a question another question in Devontae?
We do. Please ask away.
Hi, I'm Alyssa Sheridan again. And all the questions so far today have been about privacy, and my question is, what is the definition legally of privacy? Like, how does the law define privacy?
Legal definition of privacy.
Well,
Justice Hardesty?
Yeah, almost at the beginning of our history, a justice of the Supreme Court characterized it as the right to be left alone. It's received some additional permutations since then, but generally that's the springboard of the definition.
Very famous statement that I think stands on its own yet today. How about a question from Lowry?
Very good. I have a couple of young ladies at the table. Go ahead and introduce yourself and ask your question.
I'm Jessica Rackley, and I also have a question concerning privacy. Currently in Utah, there's being an institution built to keep track of all Google searches, emails, Facebook posts, and the like within the country and in and out of the country. Is this going overboard to protect our social security and disregarding our personal privacy?
Again, the question here, just restated briefly, is the government going too far in attempting to protect this security, with an example of an institution that's being built in Utah to, as I understood, to collect data from individuals? Not something that I'm familiar with, but Justice Ada?
Judge, you know what I think I'd like to do? I'd like to toss that question to our 3 classrooms. Let's start in Lowry. How many of your students think that the government is going too far?
Raise your hand if you think the government's going too far in collecting data about us. And I think that this is something that we're seeing a significant change in our country after 9/11. You know, I see a significant number of hands up here, maybe not all of them, but a majority.
How about at DeMonte? Show of hands for students who think the government may be going too far in this day of collecting data in the under the guise of protecting all of us.
I'd like to amend the question slightly, and I think it's pertinent. How many of you think that the government's monitoring Google and Facebook is a violation of privacy?
Good question.
Or how about this? How many people don't? We have some donors in DeMonte.
The point I'm making with the question is, when you post stuff on the internet and on Facebook, you lose your expectation of privacy. If the government or anyone else decides to monitor it, you don't have privacy rights anymore in what you've posted.
Thank you. How about you in Canyon Springs? Going too far? All who think we are? How many think we are not? Just about equally split here in Canyon Springs. I have one student standing before the microphone who, when I came out on Tuesday, was used in one of my hypotheticals, and she was a bank robber, and therefore I think she is entitled to ask her question.
Hi, I'm Taj, and when talking about national security and safety for the people in our society, does having advanced technology make it necessary for some people's rights to be infringed upon?
One more time.
When talking about like national security, and does having such advanced technology like computers and cell phones and stuff, does it make it necessary for some people's rights to be infringed upon when they're like being searched? Like, because some people don't know like their phones are sometimes tapped and things like that, and we're being listened to by the government and stuff like that.
Well, what's interesting is, at least in my estimation, is we have advanced in technology that has certainly raised a lot of questions in our court system, and it's created more of a conflict. And I agree with your question as to how the Fourth Amendment applies to that. But again, I go back to post-September 11. We live in a different society, and I understand that there's always that tension between privacy rights and personal safety. But when you look at the destruction that occurred and all the people that died, I think that the government ought to be allowed to use whatever means possible to make sure that our safety is preserved. Now, getting back to what Justice Hardesty pointed out, if I'm going to use Facebook, and I've got children of my own and they use Facebook, it's out there. You can't then turn around and say, wait a minute, I don't want you to get on that, government, and find out about me. You've already put that information out there. So I guess the response is, if you don't want information out there that everybody has access to, don't use Facebook. But if you're going to use that technology, be prepared that maybe you, on your own, may be giving up some of those rights.
Thank you. I'm told we have one more question at DeMonte. Is that true? One more question?
We do.
Let's hear that question.
My question was, when it comes to my individual rights, especially in school, this is more of a down to our school district, is that if you're, the question has been argued, if you're 18, what rights differ? Well, I'm 18, I have no parental supervision because I moved out of the house, I have been for 6 months, and I pay my own taxes, I work 40 hours a week to do so, all that good stuff. I was just wondering how my rights differ from my fellow classmates, or how the rights differ if you are not have no parental supervision. It's all your responsibility.
I would suggest to you that in the context of the school environment, your privacy rights will be assessed exactly the same way as your classmates because of the continued weighing principle I keep referring to. The school's responsibility to provide for the protection, the health, and safety of the educational environment, and the fact that you're 18 does not alter that evaluation. So to the extent that an 18-year-old, an adult student, is engaged in activity within the school, reasonable suspicion, the lower standard for examining your locker, will be applied. And the fact that you're 18 doesn't change the equation. What does affect you, though, is that if you are arrested, you'll be going to the Washoe County Jail instead of the juvenile detention facility, and those consequences don't change the analysis in determining your privacy rights versus the school's obligation to protect your fellow classmates.
Thank you. We are sadly at the place where we have to wrap up. A couple of shout-outs that I think are appropriate. As you may know, Law Day Live also included an easy essay contest, and there were winners who received $100 gift cards from around the state. But I want to give credit to those students and their schools who participated in the easy essay contest. Advanced Technologies Academy, James Cashman Middle School, Centennial High School, Clark High School, Coyle Academy of Science in Reno, French Ford Middle School in Winnemucca, Galena High School in Reno, Green Valley High School in Henderson, Gwynn Middle School here in Las Vegas Academy, Edward C. Reed High School in Reno, Silverado High School here in Las Vegas, Veterans Tribute Career and Technical Academy here in Las Vegas, Winnemucca Junior High School in Winnemucca, and Rooster High School in Reno. Thank you all for your participation in our contest. We hope that you will join us again next year for the contest and that we can be at one of your schools to do this broadcast. Shout out from Lowry, signing off. Congratulations on a great law day, Lowry. Congratulations on the sign-off to Demonte. Thank you all. Congratulations and a thank you to Canyon Springs. Thank you.